In addition to which, as you noted, just to confirm, I believe all the commissioners have received your letter of October 11th, and all of the exhibits that were attached to it. So that also has been reviewed by the commissioners as well. Okay.
Thank you. As the letter submitted by District Attorney Wagner points out, not only does Mr. Benetti not have any involvement in regulating or overseeing or law enforcement with respect to gaming entities or licensees, his office, in fact, does not have any such responsibilities. He also indicated that he has reviewed these circumstances and feels that, in his view as District Attorney, that Mr. Benetti is not subject to the restriction in Section 1512 of the Gaming Act. Now, just for completeness' sake, even though Commissioner Bergen indicated at the outset that the relevant inquiry here, the focus is on whether he's a public official, just for purposes of the record, 1512 precludes people from having an ownership interest if they're an executive level public employee, if they're a public official, or if they're a party official. Two of those three categories don't apply, and we're going to be focusing on whether or not Mr. Benetti's official duties as a part-time district attorney make him a public official for purposes of the Act. The Commission has published a very helpful flowchart to sort of explain the analysis under 1512 that's applicable in this context. And there's a chart for determining whether someone's an executive level public employee, as well as for determining whether somebody's a public official. And in both instances, the focus of the analysis is on what that individual's duties are, whether they have discretionary responsibilities that relate to something about gaming, whether it be over a licensee, over an individual, or some sort of policy-making role with respect to people involved and entities involved in gaming. Respectfully, based on the facts as we presented, as are indicated in Mr. Benetti's affidavit, as are confirmed by District Attorney Sean Wagner, none of those duties or responsibilities in any way involve anything having to do with gaming. For purposes of understanding Mr. Benetti's involvement in the Mason Dixon Resorts project, he is at this point a 1% owner of non-voting Class B2 shares, limited partnership units, which, if this project were to be licensed by the Gaming Control Board, his ownership interest would increase to 3.4%. But under no circumstances would he have voting rights. So that's the extent of his ownership interest in this project. Excuse me. And in light of that, if you look through the flowchart, Commission's flowchart or the statute, you can see that the characteristics and criteria for the exclusion, for the restriction, is based on whether the individual has some sort of discretionary power or rules or responsibility over gaming or gaming licensees. There's no factual basis present to show that. And similarly, if you look at the listing of various positions that the Commission's identified at the county level as having potential for inclusion under the restriction, it specifically exempts from that. It says the following positions are covered insofar as they have duties and responsibilities relating to gaming issues or licensing. So, by our understanding, and we will respectfully submit that everything that is relevant for analysis, or the main point that's relevant for analysis here, is whether Mr. Benetti has any responsibilities with respect to gaming issues or licensing, and there's no basis for that in the record, and I would be happy to answer any questions that any of the commissioners may have. Mr. Benetti is here with me, and he can answer any questions that are personal to him that perhaps I might not have at my fingertips if there are no such questions.
With that invitation, the floor is open. If any commissioners at this time have any questions, either of council or Mr. Yannetti individually. Or if you do, go ahead, John.
District attorney is elected, this one is appointed.
I believe District Attorney Wagner is elected, correct?
That would be correct, Mr. Wagner.
But Mr. Yannetti is neither appointed nor elected. His firm just works as an independent contractor.
How does he get there if he's not appointed or elected?
Well, he's not elected. My understanding of it is, and perhaps Mr. Yannetti might be able to explain the history of it in a little bit more detail, is that his firm has become involved in this capacity. Mr. Yannetti's firm has become involved in this capacity on a part-time basis to sort of supplement the efforts of the district attorney in a specific capacity. But he's not
District
elected.
attorney appointed.
No, sir, I was never appointed. My law firm was hired under a services contract. I was not appointed. There was never any type of official court proceeding or documentation appointing me to any position. Quite frankly, either myself or my partner, Gary Hartman, can fulfill the required hours of services to the counties, and he has done so on previous occasions.
Mr. Chairman, may I ask a question along those lines?
Sure.
Although it may help clarify. Mr. Yannetti, are you familiar with Section 1420 of the County Code that deals with the appointment of the assistant DAs? I think what we're trying to get at here is not so much was there a ceremony appointing you, but that it's at a minimum a de facto appointment, because the county code appears to require that the assistant DAs be appointed.
I do not believe that ever took place.
But you were sworn in, surely.
No, ma'am.
The contract required that you be sworn in as an assistant DA, but you were not?
I do not recall. It's been 16, 17, 18 years. I do not recall ever being sworn in as a district attorney.
As an assistant DA?
As an assistant.
Well, you may have some issues in that regard then. Mr. Chair, I think for purposes of the commission, you should look at this as a de facto appointment, whether there was a ceremony or not.
Well, as I understand it, some years ago, you say 17 there or abouts, that your law firm was under contract with the district attorney's office to provide supplemental services.
Yes,
Is
sir.
that correct?
Yes, sir.
And you individually and maybe other members of the firm have been doing that since then?
Yes, sir.
Thank you. John, you have further questions?
Okay. They call him a part-time assistant district attorney. You know, the lawyer does this lawyer. Okay. Thank you.
Further questions, comments?
Commissioners,
Counsel.
It's clear that at this point in time, there is no casino in Adams County. All you have is an application, and you may or may not get to have a casino there. So I think it's clear that legally clear that at this point in time, there's no way that Adams County or the DA's office would be getting any kind of distribution of revenue, because there's none to get. There's no way that you could be asked to perform duties under the Gaming Act. You focused in your presentation on the fact that Mr. Yannetti does not perform duties under the Gaming Act, and you said that he would not. I think you said he would not be asked to do that sort of thing. But what I didn't hear you address was the potential for the distribution of revenues under the Gaming Act. And I'm focusing now on the definition on paragraphs number 3 and 4. I think you've really thoroughly addressed number 5, but I haven't heard anything on 3 and 4 and how you see those applying.